So this is part 5 of my assessment of the claims made by the popular Muslim apologist Mohammed Hijab about the treatment of non-Muslims, particularly the Jews, under Islamic law. I recommend that you watch the first 4 parts, which are linked to in the description before this one, to get caught up to what has been discussed so far. So in this section, Mohammed Hijab is arguing that while there are differences between the treatment of non-Muslims and Muslims under Islamic law, this is not discriminatory or unfair because these differences are due to different responsibilities that Muslims and non-Muslims have in an Islamic state.
In what sense?
Political rights, as an example.
Yeah, well, there are some things which the dhimmis will have lesser rights in, but they will also have lesser responsibilities. Rights and responsibilities are two sides of the same coin. If we talk about people having lesser rights, it's only unfair if it's commensurate with them having less responsibilities. So yes, they have less rights in the cases where they have less responsibilities, and or in cases where value is ascribed in a certain sense, and I will say this, to a Muslim more so than, for example, a dhimmi. There are some cases like that as well. However, in a general sense, the unfair charge that there is discriminatory treatment or that there is unfair or unequitable treatment has not really been substantiated with the evidence.
Yep.
Alright, let's take a look at the evidence then. I mentioned a few other cases of discrimination earlier, but here I would like to take a look at the discrimination related to the legal testimony provided by non-Muslims in an Islamic court. This might come as a surprise to even Muslims, since providing testimony in court is a basic and fundamental aspect of any functional civil society. But Islamic law completely rejects the testimony of non-Muslims for any legal case involving Muslims. Of course, Muslim testimony against non-Muslims is completely accepted, but not the other way around. For example, if a non-Muslim saw a Muslim stealing from someone and that Muslim is being tried in court, then the testimony of the non-Muslim who witnessed that event personally is not as admissible as evidence against the Muslim in Islamic courts. Even if the non-Muslim is an honest and trustworthy person and is well known to be such by his community, his testimony is not accepted as evidence purely by virtue of him being a non-Muslim. And this is not an isolated or fringe opinion among Muslim scholars. This is a universally accepted position in Islam. Let's take a look at some references for this. In Al-Mughni, by the famous Hanbali scholar Ibn Qudamah, in the section about the requirements for a testimony to be valid, he said, if a man or woman is not sane, Muslim, an adult, or just, their testimony is not allowed. So the requirement is that the person giving testimony is a Muslim. In al-Hidayah, again, the same prominent work of the Hanafi scholar Imam Marghinani that I referenced earlier, in volume 3, page 123, we read, Allah the Most High said, and the disbelievers, they are the wrongdoers, which is verse number 254 of the 2nd chapter of the Quran, titled Al-Baqarah. Therefore, the dhimmi's testimony must be questioned. For this reason, his testimony against a Muslim is not accepted, so he is like an apostate. Next, Ibn Rushd, when summarizing the position of the scholars of Islam on this issue in his Bidayat al-Mujtahid, volume 2, page 557 of the English translation of the book, says, they, that is the scholars of the various schools of Islam, agreed about Islam that it is a condition for the acceptance of testimony, and that the testimony of a disbeliever is not permitted, except for the disagreement regarding its permissibility in bequests made on a journey. So here he's saying that the various schools of Islam all agree that being a Muslim is a condition for the acceptance of testimony, with there being one exception where there isn't a full agreement. That being the case where a Muslim who's traveling and is about to die can use non-Muslims as witnesses for his final will if there is no one else. Even in this specific case, there is disagreement between the scholars, some who allowed the testimony of non-Muslims, others who didn't. But apart from this one scenario, there is agreement that the testimony of non-Muslims is not permitted. Even modern scholars today give the same ruling. Here's a fatwa posted on islamweb.net, the largest source of fatwas on the internet regarding the testimony of non-Muslims. Pay particular attention to the reason provided for why their testimony is rejected. Question: what is the ruling on the testimony of a disbeliever? Please provide details. May Allah reward you. Answer: praise be to Allah, and may peace and blessings be upon the Messenger of Allah, his family, and his companions. The basic principle regarding a witness is that he be a just Muslim, as Allah the Most High says, and bring to witness 2 just men from among you. And Allah the Most High says, if a wicked person brings you information, verify it. In a hadith, it is stated the testimony of a traitor, male or female, or of a fornicator, male or female, is not permissible. This was narrated by Abu Dawud and Ibn Majah and authenticated by Al-Albani. So if the testimony of a wicked person is not permissible, then the testimony of disbelievers, who are the worst of creatures in the sight of Allah, the Most High, is not permissible. It is only acceptable when no other witness is available. Remember, this isn't a fatwa from a scholar living 1,000 years ago. This is a fatwa from a scholar who checks his emails every day. So according to Islam, non-Muslims are deemed legally, ethically, and socially untrustworthy, unreliable, and inferior to Muslims. There is nothing they can do to change that other than converting to Islam. The consequences of this lower status of non-Muslims carries through to other areas of the legal process too. Because if a non-Muslim isn't allowed to give testimony in court against a Muslim, is it possible for a non-Muslim to serve as a judge, which is a far more consequential position? Obviously not. And Muslim scholars have explicitly said so in their legal texts. Here is what Imam Marghinani says in his classical work on the laws of Islamic governance in the chapter on the administration of the judiciary, where he explains the conditions required to be a judge. I'm going to go over one extra point in this text which isn't exactly relevant to this topic, but it's still interesting to share. The first requirement is that he must be a man, because a woman may not take up office as she is not suited to the administrative office. The justification being verse 38 in chapter 4 of the Quran that reads, "Men are guardians over women by virtue of his having given more to them than the latter, that is, more intellect and power of discernment. Thus it is not permissible for women to rule men." The fourth condition is that he must be a Muslim, because it is a condition of legal testimony, and because of the words of Allah, Allah will never give the disbelievers away over the believers. So it is not permissible to appoint a disbeliever in judgment over Muslims or disbelievers. We see the same ruling from the Hanbali scholar Imam Bahuti as well in the Sharh Muntaha al-Iradat, where in the chapter on the requirement for a judge, he says that there are 10 requirements for a judge, and 2 of them are that the judge is male. According to the prophetic hadith, a people will never be successful who entrust their affairs to a woman, and because she is weak in judgment and lacks in reason, she is not qualified to attend gatherings of men, and the prophet did not appoint a woman as a guardian. Allah's messenger and none of his caliphs appointed a woman as a judge, and that the judge is a just Muslim, even if he has repented from slander. It is not permissible to appoint someone who has a deficiency that prevents the acceptance of his testimony due to Allah the Most High's statement, "O you have believed, if there comes to you a disobedient person with information, verify it." So it's not permissible for the judge to be one whose testimony is not accepted, and clarification is obligatory when he issues his judgment. And because it is not permissible for an unbeliever or a sinner to be a witness, it is even more appropriate that he not be a judge. So, to summarize, the Islamic position is that since a non-Muslim is always worse than a Muslim, even a sinful Muslim, because of the very fact of his disbelief in Islam, he cannot be allowed to testify against Muslims in court, let alone be a judge in any court. Every court must be presided over by a Muslim, no exceptions. This is obviously undeniably discriminatory. No Muslim living in the UK, which is where Mohammed Hijab lives, would consider it a fair ruling if the parliament were to decide that Muslims were not allowed to be witnesses or judges because their faith meant that they were unreliable and untrustworthy. Yet this is the consensus of Islamic scholars when it comes to other religions. So when Hijab says that the claim of discriminatory rules in Islam towards Jews hasn't been substantiated by the evidence, he's being deliberately obtuse, since the evidence is all over the Islamic literature and Hijab is certainly aware of it, but it chooses not to address any of it. From the statement of the Prophet saying that the end times will coincide with the Muslims being called to exterminate all the Jews, and his command to expel all Jews and Christians from Arabia, and his command not to greet the Jews and Christians and forcibly push them from the roads into the alleys and the narrowest parts of it, all of this is explicitly stated in the most authentic and relied upon texts of Islam. Yet none of this was brought up, let alone addressed. Nor were any of the legal, social, and political conditions that Jews and Christians were subjected to in Islamic lands, like the humiliation of the jizya payments and the prohibition of their testimony or of their serving as judges in courts. All of this was ignored, not brushed away or dismissed. just simply ignored as if it doesn't exist. But unfortunately for hijab, all of this is available online for Muslims and non-Muslims to verify for themselves. So this strategy by hijab and other Muslim apologists like Umar Suleiman to ignore such inconvenient facts is an entirely foolish one, because ignoring things doesn't make them stop existing.